feel like I'm forgetting something. I feel like I'm forgetting something.
Well, the sound quality I have is bad. Good morning, everybody. Welcome back to Law and Legitimacy. I'm without my decent mic, left it at home last night because I got interviewed by Laura Loomer, which was a lot of fun. And I brought my recording stuff home. Of course, didn't need it. I ended up doing the interview off of iPhone. But those of you who found Law and Legitimacy as a result of seeing us on Loomer last night, welcome. It was fun. It was, Laura is a very controversial person. She regards herself and perhaps is the most banned woman online. You know, I met her on the internet. I met her in D.C. during the Proud Boys trial. And, I was sort of starstruck. I thought, wow, I didn't know a lot about her. I didn't realize how she'd come up through Project Veritas and the controversy that she had stirred. By reacting candidly as she did to 9/11, and she's a self-avowed Islamophobe, candidly as I am. So it was a good interview. We got a chance to talk about Alex Jones. We got a chance to talk about Owen Schroyer. We got a little bit of a chance to talk about J6 and the Department of Justice. And one of the things that I found interesting about Laura is her implacable disgust over the Republican Party's failure to take J6 seriously and failure really to investigate the Justice Department or to push back in any meaningful way on the Justice Department's handling of J6 cases. And, I like that about her. It's funny, I'm looking at the screen as we talk and I'm like, who is that asshole talking? That's me. And I'm realizing he's not. I'm talking here as well. And so, check Laura out last night. We were going head to head with Tucker Carlson, which of course is never a good idea. Tucker owns the airwaves, but we still had a number of clicks and views. And, Laura has a correspondent that works with her, and she covers Congress heavily. And she's deeply critical of House Speaker Mike Johnson. And I think Mike Johnson has it coming. Mike's district is in the House Speaker. Mike's district is in Louisiana. It's where the Oakdale Penitentiary is located. And when Owen was in there, we had asked Johnson's office to look in on Owen because he'd been placed in the hole in solitary confinement. I went to Johnson's office, met with his staff, and asked for a call, gave them briefing, and never heard a word back. And so, there's good reason to question, where is Mike Johnson in all of this? And Laura called him out. We also talked briefly about January 6th cases and about Jake Lang's petition for certiorari in the United States Supreme Court. I got a lot of comments yesterday and the day before. Jake's petition has been relisted for the January 5th conference. Why aren't you reporting that? Why don't you know that? And I don't know that anybody does know that. As of the close of business yesterday, if you were to check the docket sheet in Jake Lang, the last docket entry was that his case was calendared for December 8th. And we know that the court did not reach a decision on him as to December 8th. The next conference is January 5th. That didn't help people. That didn't keep people from reporting as though it were a fact that Jake's case had been, quote unquote, relisted for January 5th. That's just not on the docket. And so I think that this is an example of people getting out over their skis, pretending to know things they don't, and acting as though they're insiders when they're so outside the loop. All they're doing is speculating and repackaging their speculation as fact. And I'm calling out Julie Kelly in particular here. Julie she has done a lot of good reporting on January 6th. She's one of the few reporters who got there early, stayed involved, and has developed a critical perspective on the proceedings and has reported in ways that are generally favorable to the defendants, which is unlike most of the reporting coming out of Washington. But she reported Jake's case relisted for January 5th. She had no basis for knowing that. And of course, I had to respond to that when co-counsel in the case, Steve Metcalf, got a note from somebody saying, how come we didn't know that? It's because we don't, and neither does Julie. So here's what we do know. In the Lang case, Lang is accused and awaiting trial. for 7 counts of assault on a police officer, obstruction of an official proceeding, and other related counts related to the confrontation in the tunnel to the West Mall. I call it the Battle of Thermopylae, where a group of officers stood at one end of the tunnel and a group of protesters entered from the other. And for hours, there was a standoff, and it was violent, and there's no two ways about it. Roseanne Boylan was trampled to death in that environment, and Lang removed certain people who were struggling health-wise from the area. And he has been charged with assaulting cops. His defense at trial will be that he was acting in defense of self or others, and a DC jury will have to decide that. Along the way in his proceedings, Steve Metcalf, who at that point was sole trial counsel, right now I am in the case, at least for the time being, as trial counsel as well, should the case be reached for trial anytime soon. But Steve filed a motion to dismiss the 1512 obstruction of justice count. If those of you who are new to the issue, listen up. 18 United States Code, section 1512, relates to obstruction of official proceedings. And sections A and B talk about destruction of documents or tampering with witnesses. And so a person who corruptly destroys a document or tampers with a witness in anticipation or in an effort to interfere with an official proceeding is guilty of that felony. And that felony carries up to 20 years in prison. This statute was applied in the Enron case and against Arthur Anderson and some accounting firms. The law was insufficiently broad to capture all the conduct that prosecutors wanted to capture in that case. So Congress amended 1512 and it put in a section C. And C says, if with a corrupt purpose, a person, quote unquote, otherwise interferes with an official proceeding, they're guilty of that felony. And so we had a felony that was at first directed solely toward destruction or making unavailable or tampering with evidence set to be presented to an official proceeding, that was expanded by section C to include just what exactly? According to federal prosecutors in the January 6 cases, it covers everything relating to any disruption of an official proceeding, even entering the Capitol and screaming while Congress is trying to count electoral votes.
Yeah, well, obviously, that's what they needed to be, Norm.
And so Lang Lang had a trial court judge who dismissed, as did 2 others, Fisher and Garrett Miller. And these cases went to the District of Columbia's Circuit Court of Appeals. And in a 2-1 ruling, that court held that the statute was correctly applied. I filed a petition for certiorari for Jake Lang. Fisher's lawyer then filed another one. Miller's lawyer then filed the third. And all 3 are pending before the court and consolidated. And so this is the issue before the Supreme Court. It has resulted in a delay in Lang's trial because the government isn't backing down from the 1512 count, and Jake can only afford to try the case once. So while we wait for the Supreme Court to act on the 1512 count, Jake sits behind bars. It's been more than 1,000 days. So I don't know what's going to happen. I know that on December 8th, the court granted 3 or 4 writs of certiorari. That is, it decided to hear fully on the merits issues in 3 or 4 other cases. It rejected scores of other petitions. It said no. What it didn't say to Jake and others with respect to the 1512 count last week was no. And so that, to my mind, is a hopeful sign. The case is still alive. Let's see if it's reached on the 5th of January. It may not be. Nobody tells the Supreme Court what to do and when to do it. There is no further court or higher court of review. They'll get to it when they get to it. Yeah.
Well, Roger Parloff, who you're familiar with from his reporting on the January 6th, the Proud Boys January 6th seditious conspiracy trials, he was quoted on X as saying essentially the same thing, that he believes it does increase the statistical likelihood of a grant. And as far as the DOJ is concerned, it's an unwelcome but not catastrophic news. But it does appear as though the general consensus is that a the lack of an outright denial spells something. But if I were you, Norm, and I know you are this way, you just got to wait and see. And there's not a whole lot to be gained from.
No, I mean, because it just, it could mean that somebody wants to write a dissent, and they weren't ready to dissent on the 8th. There's been a little bit of internecine arm wrestling among the lawyers involved in the case. Some of the lawyers think that only they can argue the case and that others like me can't. And so, there's been an effort to mobilize, the legal academia away from Jake's case in favor of Miller's or Fisher's. And, I'd like to believe the Supreme Court isn't influenced by this egomaniacal arm wrestling. From my perspective, we filed our petition. We're waiting. We have another petition up there, though, that I want to just mention briefly. And it relates to the warrants clause of the Fourth Amendment. And it relates to the concept of qualified immunity. In a case arising out of Connecticut, this case is called Doe versus Parisi being the lead officer. In this case, police officers got a search and arrest warrant, and it relied in part on some bad information. And the criminal case was dismissed. The Doe, our client, brought an action for false arrest, claiming that they relied on a bad warrant. And the trial and lawyers for the cops filed a motion for summary judgment saying the officers were entitled to qualified immunity, that their conduct wasn't against clearly established law. And the trial judge denied that motion, saying it was a bad warrant. The District Court of Appeals, the Second Circuit District Court of Appeals, reversed, saying there was quote unquote arguable probable cause. Even if there wasn't probable cause in the warrant, it was close enough to entitle the officers to qualified immunity. We called bullshit in a petition to the Supreme Court and basically reminded the Supreme Court that there's a clause in the Fourth Amendment that says no warrant shall issue, but without an affidavit, finding probable cause. If you don't have probable cause, you can't have arguable probable cause, because shall in a lawyer's life is a word meaning that it's mandatory. And so we're hopeful on that petition. We know that the United States Supreme Court has been looking to take aim at qualified immunity and discuss whether it belongs in the law at all. We hope they get to it. Which leads me to my daily rant on Jalapeno Jack. So, here we've got Jake Lang sitting for 1,000 or more days awaiting trial. His case bounced up to the U.S. Supreme Court as a result of some interlocutory rulings on a count carrying 20 years. We've got another individual with a case complaining that the government arrested him and on the authority of a bad warrant. And we'd like the court to hear those cases. These cases have taken years to percolate through the system, and the interests involved on behalf of the clients are very vital to those clients. Jake's behind bars right now. It doesn't get much more real than that. John Doe's reputation was destroyed as a result of what we call fraudulent law enforcement conduct. He'd like his reputation and his life back. So Jalapeno Jack, he's set his sights on Donald Trump. They want to they want to try the case in March of 2024. This is Donald Trump's January 6th case in DC. It's set for jury selection. Trump's lawyers file a motion to dismiss, claiming that Trump's speech cannot be used as evidence against him because he's immune for utterances he makes as president. The DC Circuit Court of Appeals decides in another case he's not entitled to immunity. Judge Chutkan agrees with the DC Circuit and says, no, that speech can come into evidence. Donald Trump's lawyers then do what the law requires them to do. If they want to have review of this, they file a notice of appeal in the DC Circuit Court of Appeals, and they, I guess, are awaiting a briefing schedule. The result of this should derail the trial. Smith doesn't want the trial derailed, so he's gone directly to the United States Supreme Court saying, we want a writ of certiorari. We want you to use your discretion to hear this case in a special way, outside the normal rules of appellate procedure. And it's in the public interest because we need to have our trial in March. Why, Jack? I mean, candidly, if there is when Trump has been talking,
I need. Anybody want to
jalapeno. But when people have been talking about Trump in particular, Smith's litigation as election interference itself, it's kind of gone over my head as sort of typical rhetorical excess coming from Orange Man Bad. But now this sort of proves the point. Jack, there is no compelling public interest that require that you have your trial set to begin the day before primary seasons so that you can tie up Trump in a criminal case while he is the leading Republican contender for the nomination for president, unless, of course, your objective is to derail that nomination. And Jack, isn't that of a piece with everything else your jackass Justice Department has been up to with respect to January 6th? Obscene, overreaching applications of 1512 to make rioting, obstruction of an official proceeding similar to destroying evidence or tampering with a witness. Isn't that the same as the ridiculous effort to declare people who participated in the protest terrorists? I haven't had a chance to check the docket sheets today, but it's very interesting, and I wish I had. I'd forgotten to. Charles Donahoe was another of the defendants in the Proud Boy case. But he entered a plea prior to trial, and he was on the government's witness list. They never called Donahoe. I think it's because the defense destroyed the other cooperator they called, Jeremy Bertino, and Donahoe would have testified that there was no plan to storm the Capitol that day. That was clear in his statements. However, he's set to be sentenced soon, and yesterday I noticed at around 6 p.m. His defense lawyers filed their sentencing memo to the court. The government, I presume, filed theirs later in the evening, and that's what I forgot to check. But I am willing to bet that the government did not do to Charles Donahoe what it did to Joe Biggs, Zach Grell, Dominic Pizzola, Ethan Nordine, and Joe Biggs, and that is seek to have them declared terrorists. And if the government does not do that as to Donahoe, that will tell us the following: that these men who they sought to be declared terrorists, their offenses is terroristic. They were declared terrorists because why? Because they went to trial. Donahoe pled guilty, was engaged in the same conduct, and he doesn't get the terrorism enhancement. Jalapeno Jack, Madman Merrick, you've got some splaining to do. And that splaining has to do with how you're treating the January 6th defendants. You've made this into a thing. It was a 6-hour riot that could have become a minor footnote in American history, but is now becoming a vast divide and is now becoming a club, not only to take out a presidential candidate, but to intimidate those who support that presidential candidate and to inhibit their participation, not just in the 2024 election, but in a protest over whatever might occur in the 2024 election. It looks transparent. And, when I was on Laura's show last night, I was trying to inspire her, because she's got clout, in ways that we don't, to rabble rouse, to defund the DOJ. I'm not talking about shutting the department down in general, but if you're a congressional Republican and you've got the power of the purse, why not target certain things that the DOJ is doing and refuse to fund it? And one of those things would be the Jack Smith prosecution of President Trump and his seeking immediate Supreme Court review so that he can put the president on trial during the presidential primary while he's prosecuting still looking for more people to prosecute those who protested on January 6, 2021. At some point, this national preoccupation with that now long past piece of history has to end. And we have to realize there's something more terrifying than interfering for several hours, or even if it had been several days, with the peaceful transfer of power. And that is letting the government criminalize those it disagrees with and seeking to chill, incarcerate, and destroy the lives of those who stand up and act out in protest. Jalapeno Jack, you are rapidly becoming one of the most dangerous men in America. I hope the Supreme Court throws you out on your ass. Let me repeat that. Jalapeno Jack, I hope the United States Supreme Court throws you out on your ass. There are people who played by the rules, have waited for years for their shot at justice, and you're demanding that this courtroom be used for your political purpose or your boss's political purposes in March of 2024. Don't you think we're watching? Don't you think we see you, Jack? Don't you think we know what you're doing? And do you really think you're going to inhibit and terrify and scare the American people into calling bullshit when we see it? Jalapeno, Jack, go swallow another jalapeno.
Just amazing. It's amazing to me that we're on the other side of however many failed impeachment efforts onto President Donald Trump. One as recent as, before President Biden was sworn in, took the oath of office. And this is what's being expedited as a challenge as unto Trump's immunity.
Yeah, no kidding. Well, I'll say this much, though. At least Jalapeno Jack isn't letting AI do his legal research. What in the world is up with Michael Cohen's criminal defense lawyer? What happened now?
So if you recall, this case was actually closed. Man, was it 2018 or 19? I believe it was the end of 2018 that this case against Michael Cohen was closed. And of course, Michael Cohen was a former lawyer for President Trump. He was he was adjudicated guilty of, tax evasion and a couple of other things. He pled guilty on a number of charges there in the Southern District of New York. And he was released under supervised probation. Apparently, several weeks ago, his attorney, one David M. Schwartz, filed a motion for early termination of that supervised release. And as part of that motion, his attorney asserted that as recently as 2022, there have been district court decisions affirmed by the Second Circuit Court granting early termination of supervised release. He then cited and described, quote, 3 such examples, Norm: United States v. Figueroa Flores, United States v. Ortiz, and United States v. Amato. And this is where it gets interesting. I'm going to put this on the screen. The court says, as far as the court can tell, none of these cases exist. Federal 4th 223 refers to a page in the middle of a Fourth Circuit decision that has nothing to do with supervised release. Let's see. Moreover, the court contacted the clerk of court in the United States Court of Appeals for the Second Circuit, who found no record of any of the 3 decisions and reported that the one listed docket number for Ortiz is not a valid docket number. So here we are. In light of the foregoing, Mr. Schwartz shall, no later than December 19th, 2023, provide copies of the 3 cited decisions to the court. If he is unable to do so, Mr. Schwartz shall, by the same date, show cause in writing why he should not be sanctioned pursuant to Rule 11B2 and C of the Federal Rules of Civil Procedure, 28 U.S.C. 1927, and the inherent power of the court for citing non-existent cases to the court. Any such submission shall take the form of a sworn declaration and shall provide, among other things, a thorough explanation of how the motion came to cite cases that do not exist and what role, if any, Mr. Cohen played in drafting or reviewing the motion before it was filed. So that last sentence is where I started with you this morning before we got on the stream, Norm.
Well, I didn't realize that, and I understand that. But do we know anything about what Schwartz did? Is this another piece of open AI legal research?
We don't have to wait very long, and we will find out. Mr. Schwartz is obligated now. And to be clear, Michael Cohen now has a different attorney, and that attorney is referenced in this order as well. The court acknowledges in this first footnote, the court is apparently not alone in being unable to find the cases. New counsel entered a notice of appearance on Mr. Cohen's behalf after the government opposed his motion and with the court filed a reply letter. The reply letter asserts that many courts in this district have granted early termination of supervised release in similar circumstances, and after citing various cases, includes the following footnote. Such rulings rarely result in reported decisions. While several cases were cited in the initial motion filed by different counsel, undersigned counsel was not engaged at that time and must inform the court that it has been unable to verify those citations.
So as a matter of legal ethics,
appear like she knows what she's talking about, aka these sorts of decisions are rarely reported. They don't usually show up in your legal research tools, right? Number one. So it's not like we needed a whole lot of precedent. And I think you said that, Norm. You're a practicing criminal defense attorney. You know this. And you actually said that in these circumstances where you're filing a motion for, the court to consider granting, a termination of supervised release, it's not as if you need to do a legal brief to SCOTUS.
No, and so, typically a person on supervised release has already served the custodial portion of their sentence. This is the back end of the sanction. Call it probation, if you will. Supervised release is the functional equivalent of probation. They have a reporting relationship to a court officer, and so long as they remain within the confines of that reporting relationship and the rules that the court imposed or the supervisor requires, they remain at liberty. And typically, if a client has done everything right, around the halfway point of the supervised release period or shortly thereafter, you file a motion asking the court to use its discretion to release the person from supervised release. Often you have the support of the supervising parole or probation officer, and the court looks at it, and every criminal defense lawyer who's been practicing more than about 9 seconds knows that the court has the discretion to do this. What you want to show the court is that the defendant has been fully compliant, and that both, the government can save resources by not having to supervise him, that justice has been done, and the purpose of imposing the criminal sanction has been served. And, courts will usually, if there's no opposition, depends on the judge, some will grant, some won't. If the court does not use its discretion to release your guy, I don't know anybody who's taken appeals over that. And so, the lawyer who filed this on Cohen's behalf might be going to the Box of Rocks Intelligent Enhancement School, where you take classes on how to improve your IQ that include hit yourself in the head with a hammer 7 times in 9 seconds and recite the ABCs backwards, or bang your head against a wall, or better yet, just type your question into OpenAI and recite whatever it gives you back. It's a real bad move on behalf of his lawyer, and I suspect the lawyer is going to suffer consequentially. Now, whether Cohen is involved, Mike, you raised an interesting question. Cohen is going to testify in some of the Trump proceedings to come, and can this be used to impeach Cohen? Lawyers have a duty of candor toward the tribunal. That's a professional responsibility that the rules of professional conduct impose. And that means that a lawyer cannot withhold from the judge knowledge of authority. That is a case that decides an issue adverse to the client's position. And so if I'm trying to get the judge to issue a ruling that something tastes great and another judge concluded it was less filling, I have to say, Judge, I think it tastes great. You should decide it tastes great. Here are the reasons, but Judge so-and-so says, it's less filling. Included within that rule is not making stuff up and throwing it at the court as though it exists. So that lawyer's got problems. If Cohen played a role in drafting the document, I think Cohen's got a problem. And he can be
a question, just to be clear, I brought this up because the order does specify that issue, that sub issue must be affirmatively addressed in the show cause to the court, right? The court has said, not only are you supposed to provide a sworn declaration and an explanation of how those non-existent cases were embedded in a motion that you put toward the court, but you must also affirmatively tell the court what role, if any, the defendant had in drafting or reviewing that motion prior to its filing with the court. And that's interesting to me because of these things that are going on in New York with respect to Trump, notably Letitia James and Alvin Bragg.
So the way the court wrote that, it's not a model of clarity. What role, if any, Mr. Cohen played in drafting or reviewing the motion before it was filed? So if Mr. Cohen wrote it and gave it to the lawyer saying, file this for me, then I think Cohen could be impeached with offering, because he did have a law license at some point and presumably knows how to conduct legal research, is presumably, even if he's not a practicing lawyer now, aware of the responsibility not to mislead the court. So if Cohen drafted that motion and gave it to his lawyer to sign, then Cohen is responsible for putting false information in it. If all Cohen, and I can see that as creating a problem for Cohen going forward. If he reviewed it, however, if his lawyer prepared it and said, Mike, I'm going to file this for you, take a look at it, will you authorize this? Cohen looked at it and passed it along. I think he's okay. Because in that case, you're not expecting him to check his lawyer's citations and to confirm that his lawyer looked at actual cases as opposed to making them up. And so now the lawyer, here's where it gets interesting. Let's take a look at the affidavit on the 19th. if the lawyer says Mike prepared it, he's throwing his client under the bus. But he's not absolving himself at all, because he still has a responsibility to check the pleadings he files. If he prepared the motion and Mike simply reviewed it, then it's all on the lawyer. And so, the temptation for the lawyer is going to be to try to blunt his responsibility for this in ways that hurt Mike, which would be disloyal to his client. So it's just a legal ethics nightmare, any way you look at it. And, Mike, I know you're a hawk on these issues. You think that people who do this should be disbarred. Maybe you're right. I don't know.
One thing, I was trying to find the judgment in this case. I'm on Pacer right now, and if I can pull up the judgment, my question, Norm, and maybe just a point, not sure how far this will go, how productive for this conversation it'll be, but the crimes that Michael Cohen pled guilty to and were also adjudicated guilty. So those are not necessarily the same things. That he was charged with 8 or 9 things. What about the fact that they were crimes involving moral turpitude, as it were, right?
No, I get that. And so, he's been sentenced to prison. He's got supervised release. The purpose of the criminal justice sanction is to punish a person, to protect society, to provide an opportunity for rehabilitation. And I forget what the fourth one is. And so, if Mike was involved, if Cohen was involved in preparation of a fraudulent document and the underlying charges involved moral turpitude, that suggests that the purpose of rehabilitation has not been fulfilled, and we need to hold on to him. I think there's a stink factor, and I hate to sound catty, but it's worth remembering that Cohen is a graduate, I believe, of the Cooley School of Law in Michigan, which for many years was rated as the worst law school in the United States by people who do such things. And I've met other graduates of the Cooley School of Law, and I don't know what they teach people or taught people there a decade or so ago, but it didn't bear much relationship to the law that I practice or to the skills that I need for lawyers who work in my office. So, let's take a look on this as it evolves. It's more embarrassment. I don't know that we can say yet that it sticks to Cohen. It may well. The trial judge has his suspicions. I think from Cohen's perspective, or from Cohen's lawyer's perspective, what did he think would happen? I mean, you've got one of the most high-profile defendants in the country, where you can presume everybody's looking, and you're going to let ChatGPT or some bot do your legal research for you. And when it produces citations, you're not going to double check to see that those cases actually exist. You're not going to do so when it's already a thing in the Southern District of New York that people have been caught filing bogus pleadings with non-existent citations. Maybe you're right. Maybe the guy should be set down.
Yeah, and here's the thing, right? I think that seasoned attorneys who have practices that are very productive, they have limited bandwidth, and they are hiring younger attorneys to come in and do the more garden variety, rote level, voluminous work, right? Routine motion practice, these sorts of things. This may be an inherent tension that has not been discussed, Norm. Perhaps Mr. Schwartz really is at fault for one thing, and that is lack of custody over his office. This seems to me like something where this task was delegated to an underling, and the underling, inexperienced as that underling might have been, did not know what to do, did not want to ask, if there's a form for this, right? As younger attorneys are inclined to do these days for whatever reason, and didn't make it a priority to just sit and discuss this thing for fear of, embarrassment or whatever. I'm making all of this up, Norm. I'm trying to figure out a way to repair what Mr. Schwartz would have otherwise done in this case.
There is no repair for it. I mean, look, there's no repair. It came under his signature, and the court is entitled to rely on his integrity and his having done the research himself. And
what a ridiculous mistake to be the defense counsel for someone with notoriety like Michael Cohen. And for this, on the back end of the case, the entire case is done, Norm.
For years, I've had associates, that is, younger lawyers, work for me, and I rely on them to do legal research for me. And some of them have been brilliant, and one's now an appellate court judge in Connecticut. Some of them less so and haven't lasted long here. Almost all of them are good, and they remain. And I develop a level of trust in their work. I have signed pleadings prepared by associates without double checking their work, and I think I'm entitled to rely on them. However, if I rely on them and it turns out there's something wrong, then it's on me. I mean, here's a funny story. This actually happened. It was about 25 years ago. That's how old I am. I was in a courtroom trying a civil rights case, and my then partner at the time was a man named John R. Williams. We've interviewed him on the stream. He's now in his mid 80s, and he's fading away, which is sad to say and sad to see. But he had written a textbook on litigation of the type we were pursuing there, 42 section United States Code section 1983. And there was a case he cited in there that stood for some proposition. And I was arguing to the judge. And the judge was Alfred V. Cavello, no friend of the plaintiff's bar. I'll get more to say about Cavello on another occasion. And I was arguing some point, and Cavello looked at me and he said, "What's the citation on that again, Mr. Pattis?" So I looked in the book that I was reading from John, and I gave him the citation. We're going to take a break. Cavello came back into the courtroom with a volume of a legal volume, and he said, "I'm going to ask you to find that language in this case for me." And I looked, and it wasn't there. Ooh. And so, what I'd done is I relied on one of the leading treatises in the United States by my senior partner on a legal proposition, and I didn't double check it because I trusted my partner and I trusted the publication, and my trust was mislaid. So I read it and I said, I must have been in error, and I apologize. That was an earlier example of this, and I think every lawyer needs to hear that story, and you do hear about it in legal research. You've got to do your own research. The problem is, as you advance in your career in the law, you've got more and more coming at you. You become part of larger and larger organizations, and you're depending on more and more people. Right now, there are lawyers who outsource work to people out of the country, where they can pay somebody to do pleading work for them in the Philippines and maybe pay them $15, $20 an hour, and then they're signing this stuff. Do they even know the people that are working for them? Do they even bother to read the material? So I think that these ChatGPT nightmare cases are teaching us a lesson about the outer limits of the law, and teaching us a lesson about the fact that lawyers really are not replaceable by machines or by machine learning.
But it is a fundamental threat to our justice system if this is not taken care of. I think that the state's bar associations and organizations should be reacting to this with a heavy hand. Personally, I think it's obviously in my interest as a small shop attorney, but my clients must trust me. That's the only thing I have, right? At the end of the day. And
I got you.
And the fact that this could be put in front of the court in a case as high profile as this, on a motion as inconsequential as this, is really troubling to me. And it's only because the court looked.
Yeah, I know. I hear. Well, at least somebody was doing their work. So look, we've run to the end of the time here. We didn't get a chance to talk about the growing split between Joe Biden and Benjamin Netanyahu over Israel's efforts in Gaza. I want I want to talk about that tomorrow, because I think there's a piece of there's a post going viral on the internet right now where there's a Hamas leader saying, "Jews are everywhere. We will continue killing and slaughtering Jews in every city on the planet. We want to see knives. They cost 5 shekels. How much is a Jew's throat worth? 5 shekels? Or even less, God willing. All of our people are ready to blow up. We've built a new factory for explosive belts." And he goes on, glorifying the destruction of Jews everywhere. The United Nations Security Council rejected a call for a ceasefire in Gaza, but the floor vote from the General Assembly produced one. And so there is this notion that somehow the world is turning against Israel and in support of Gaza, at least a ceasefire, while Hamas leaders embedded in Gaza are calling for the destruction of Jews. Has the world gone mad? Are we prepared to tolerate that in the name of freedom of speech? Or have we not reached a tipping point where we are going to say we will tolerate the tolerant, but there is an outer limit. And when you engage in savagery, you can expect the full hand of violence, a violent response of the state of Israel and of civilized people everywhere to come down upon you. And if you hide behind innocent women and children in your community, that's not going to be sufficient to keep you from being extinguished, because civilization is valuable. And, Hamas, in my view, is not. So let's talk about that more tomorrow. I'm concerned that Biden and the United Nations are starting to prove the point of what globalism means, and that rather than globalism being the tool of this protocol of the elders of Zion, people like to use this as a trope for anti-Semitism. Maybe the real danger is that globalism is turning against Western civilization, and globalism and global institutions in targeting Israel and permitting Israel to be targeted are showing their throats, that maybe it's time for the globalist throats to be sliced, in a metaphorical way, of course.
Always in a metaphorical way. I was reading a little bit about that this morning as well. I saw some reports about Hamas leaders going missing, unaccounted for, cell phones off, etc. So plenty to discuss there tomorrow. We will do that. I want to thank Laura Loomer for having Norm on Loomer Unleashed last night. I was in the chat on behalf of Law and Legitimacy there on Rumble, kind of banging the drum, and that was a very lively chat. I think there was over 1,200 people watching your segment live, Norm, and to great reception. People respect what you're doing, what you have done, and what you continue to do. So I think it's important. If you get a chance, everybody watching, just I think it's toward the first third of that stream last night. Norm was on there for about a half hour. Really productive stuff. Go check that out. You can find us here every day at LawPod Daily on X. We're also on Rumble and YouTube Live. And if you don't catch us live, or you prefer the audio only, we're on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. Rate us 5 stars. Subscribe, enable notifications, do a bunch of stuff that you don't think matters, but I can promise you in the cumulative matters a ton to where we're taking this platform. We appreciate you. We're grateful for you being here. Thank you for everybody on Rumble talking this morning. And Norm, are you prepared for Lawyer Will this week or what?
My team is consuming protein bars and attending motivational speeches given by Alex Jones. So, Will, we're coming in over the wire. We know where your team is. We know where they sleep. We're going to extinguish you in the name of liberty, in the name of the people. This is Alex Jones in support of the objectors in the first round of the Law and Legitimacy playoffs. Lawyer Will, your ass is grass and we are the lawnmower.
See you, Norm.